Okay, Mr. Krist, whenever you're ready.
May it please the court, Austin Krist on behalf of appellants Clay and Lindsay Buchholz. In 2017, the Buchholzes discovered that their home was riddled with mold, and that mold made the house uninhabitable until it could be removed. The home was insured by an insurance policy issued by appellee Crestbrook Insurance Company.
Mr. Krist, yeah, we have all the underlying facts because we've read the brief, so why don't you move on to your legal points?
Of course, Your Honor. So under Texas law, the Buchholzes bear the initial burden of putting forward evidence of a covered cause, putting forward evidence that their losses fall within the scope of coverage provided by the policy. Here, the Buchholzes have an all-risk policy, which means that the policy covers all risk of accidental direct physical loss and all causes of loss unless an exclusion applies. And as this court has previously observed, the purpose of all-risk policies like the Buchholzes is to provide coverage in situations where it is difficult to determine precisely or specifically how a loss occurred. I'd cite to two cases, and we have cited to those cases in our briefing, Morrison Grain versus Utica, in which the Fifth Circuit explained that all-risk policies arose for the very purpose of protecting the insured in those cases where difficulties of logical explanation or some mystery surround the loss of or damage to property.
Let me ask you, in addition to the all-risk policy, they also purchased additional mold coverage. So what did they think that covered?
Well, Your Honor, I think our position is that the additional mold coverage that the Buchholzes purchased took the form of an exception to an exclusion. The policy contains an exclusion for mold, and by purchasing the mold coverage, they received an exception to that exclusion that then provided them mold coverage under the policy. All exceptions provide coverage in that way, and that's what we contend the exception did here.
And so what mold did the insurance company refuse to cover? Was it just in the HVAC, or was it throughout the whole house? What was that last item?
Excuse me, Your Honor. So there were 6 claims that the insurance company instructed the Buchholzes to submit. 5 were for mold and water damage in specific rooms, and the insurance company covered those. Then they instructed the Buchholzes to submit a 6th claim for mold and water damage throughout the home that the insurance company contended resulted from a global issue, and the insurance company did not cover that claim. It's a little unclear to me exactly how the insurance company allocated damages among those claims, but there's no dispute that there's an outstanding amount of money that the Buchholzes spent to restore their home that was not paid by Crestbrook as a result of the denial of that 6th claim.
As a result of the mold?
That's correct, Your Honor. There are damages in the record that the Buchholzes spent money to restore their home from this mold damage, including about $390,000 for Cotton Commercial, which provided remediation services directly for the mold. And there are other damages in the record as well.
So it's your position that there's this general all-risk policy. There is an exclusion for mold contained in the policy, but they paid extra premium for an exception to cover mold. But it says that exception, I guess, says, I don't know if it's a policy right or I'm going to use the wrong terminology, but that separate coverage says that they'll cover mold for a covered cause of loss or resulting from a covered cause of loss. What's your definition of that?
Your Honor, we would propose that covered cause of loss just means any cause of loss that is not excluded under the policy.
That it relates back to all risk.
That relates back to all risk.
In other words, as I read the magistrate judge's report and recommendation, the plaintiff's claims failed because they failed to show a specific cause of the mold in question, and they had the duty to do so. Your position is all risk policy. We may have a duty to do so, but it's not presumed necessarily, but they did so by showing we've got this coverage and there was mold. Is that right? Or talk about that.
Your Honor, I think I would put it a little differently. I believe that the Buchholz's duty is to put forward evidence of covered losses, and the policy covers all accidental direct physical loss regardless of cause. And so the Buchholz's burden there is to put forward evidence of the loss, not evidence of the cause. And we believe that's where the lower court potentially went astray. And I know that Crestbrook has made the argument on appeal that the Buchholzes were required to identify a cause of loss. In our position, it wouldn't really make any difference what cause of loss the Buchholzes identified, because regardless of the cause they identify, their losses will still be covered as accidental direct physical loss unless Crestbrook.
Not so fast, because I thought that the Buchholzes had an expert that had come in and looked at everything, and one of the conclusions was, well, it was the HVAC system. In other words, it was a faulty design, something in the construction process, which I thought was excluded from the coverage of the policy.
So, Your Honor, the Crestbrook paid to have an expert come out, which was in-law forensics, and then also Tom Green is another expert that contributed to that report.
That wasn't a Buchholz expert?
Well, that's really, the characterization depends on which party you look to. Crestbrook claims that it's the Buchholz's expert, but
I'm looking to you right now, so
the Buchholzes contend that that expert was hired by Crestbrook, and the conclusions that that expert reached were preliminary. And if you look to our brief, specifically our reply brief, we've cited how the reports that Tom Green and Dean Reed, the in-law expert, put forward were preliminary. He did no quantitative analysis whatsoever. And so then, after their claims were denied, the Buchholzes went out and hired another expert, Sean O'Brien, and Mr. O'Brien opined in the report and in the declaration that the Buchholzes submitted at summary judgment that there are fact issues. Well, his opinion was that the HVAC system did not contribute to the mold. His opinion was also that the other set of defects and, I guess, house issues identified by Crestbrook, which was thick wall paint, paneling, and trim, also did not contribute or cause the mold in the Buchholzes' home. And so there is a conflict between what the preliminary in-law report says in terms of what caused the mold and what the Buchholzes' expert here, Sean O'Brien, says caused the mold. Mr. O'Brien conducted quantitative analysis and went through various schemes in order to determine what the actual cause of the mold was, and he determined that there was no evidence for the cause identified by Crestbrook. And that's important here because Crestbrook bears the burden of establishing whether these losses resulted from an excluded cause of loss. The district court did not reach any of those exclusions here, and so those would be an alternative grounds for affirmance if this court chooses to reach them. I'd also be happy to address any of the specific language of those exclusions if it would be helpful for the court, but our overarching position is that because there is a fact issue created by the conflicting expert testimony as to what caused the mold, there are fact issues on those exclusions that prevent or that would preclude determining whether they're applicable here as a matter of law.
What did the district court say about the meaning of covered cause of loss? Anything?
Your Honor, I don't believe the district court defined the term covered cause of loss. They just said that, well, the Buchholzes had to identify a covered cause of loss in order to show coverage here, and because they didn't, then the policy did not provide coverage for the losses. And we've disagreed with that for two reasons. Number one, the phrase covered cause of loss can only reasonably be interpreted in one way, and that's any cause of loss that is not excluded. The policy does not define the term covered cause of loss anywhere, and all causes are covered unless it's excluded by a particular exclusion because this is an all-risk policy. Separate and apart from that issue—
There's no dispute that the mold addendum that they paid extra premium for is generally more generally governed by the policy itself. In other words, there's no dispute that the all-risk language in the principal policy would carry over to the mold coverage?
I certainly would not dispute that. I'm not sure if Mr. Gillett will, and I'll leave that to him, but we certainly believe that it's an exception to the mold exclusion in the policy and that the coverage provisions of the policy are governed by that overarching section that says the policy covers all risk of accidental direct physical loss unless otherwise excluded.
So do we, in the first instance, grapple with the definition of covered cause of loss, or do we send it back to the district court to do so if we agree with your argument?
Your Honor, I believe that this court could grapple with the phrase covered cause of loss because I believe there's only one reasonable interpretation of that phrase, and if it's unambiguous, then it could be construed by this court as a matter of law.
I mean, it's a legal issue, right, the meaning of the contract?
That's correct, Your Honor, and it's especially a legal issue here because under Texas law, to the extent that that phrase is susceptible of two readings, then this court is required by Texas law to adopt any reasonable interpretation in favor of coverage because the phrase covered cause of loss is necessarily defined by reference to the exclusions in the policy. The policy covers everything else. And so we would, even if it's ambiguous, urge the court to adopt our reasonable interpretation of that phrase here. The other thing that I would like to point out is that there was really no dispute at the district court level regarding the direct cause of the mold. Everybody, including the Buchholz's expert, Crestbrook in its motion, and the lower court in the report and recommendation, acknowledged that the mold resulted from water and accumulated moisture within the walls of the home. The dispute between the parties was really how the water and moisture got into the walls of the home, but if you look at water and moisture, that is a cause of loss that's covered because the policy covers all causes of loss resulting in accidental direct physical loss, unless Crestbrook can show that it's excluded. And here, Crestbrook has tried to point to several exclusions in the policy to explain why that water and moisture got into the walls, and Crestbrook has claimed that they're excluded, but there are fact issues precluding judgment on those exclusions here as a matter of law.
Didn't the mold get in the 5 rooms the same way?
Well, Your Honor, it's possible that...
The 5 rooms that were covered?
So Crestbrook contends that the water and mold in those 5 rooms also resulted from water and moisture in the walls, but they claim that that water and moisture got there as a result of leaks in specific rooms, and they say that that was localized, whereas the 6th claim was for unexplained mold throughout the rest of the home. And it's because there is uncertainty regarding how the globalized mold ended up in the rest of the house that the Buchholz has purchased this all-risk policy in the first place, because these policies, again, exist to provide insureds with coverage in situations where it's difficult to determine the loss, but everybody knows that a loss occurred. If the court would like to discuss any of the specific exclusions in the policy, then I'm happy to, but otherwise I will move past those.
So what, if we agree with you and vacate and remand, what are the facts that the district court will need to determine?
Well, Your Honor, if this court vacates and remands, then the district court would have to determine whether, first, there are fact issues on these exclusions that have been cited by Crestbrook, and we believe there are here, and if this court would like to determine that there are fact issues on those exclusions, then the case will probably go straight to trial in order to determine whether, or I guess to determine the amount of damages that the Buchholz has suffered, because there are fact disputes regarding between the parties regarding the amount of damages that relates directly to the mold.
Well, before we get to the amount of damages, just on the question of liability, would there be fact issues in the district court on remand as to liability, as to coverage, that is?
It's our position that there would only be fact issues as to liability if this court does not address the exclusions. If this court addresses the covered cause of loss issue and then overlooks the exclusions because they would be alternative grounds for affirmance, then the lower court would have to determine whether there are fact issues precluding application of those exclusions. And if there are fact issues, then those exclusions would have to go to a jury in order for the jury to determine whether the losses actually did result or did not result from that excluded cause. They'd have to resolve the conflict between that expert testimony.
The district court didn't grapple with any of the other exclusions, though, did it?
No, Your Honor. The district court said that it did not reach any exclusions in the policy.
Yeah.
So, and I guess to summarize here, both parties agree that the Buchholzes are entitled to coverage for mold resulting from a covered cause of loss. And there's no dispute that the Buchholzes put forward evidence of accidental direct physical loss to their property. That is evidence of coverage. And under the policy, all causes of loss resulting in accidental direct physical loss are covered unless an exclusion applies. We believe the Buchholzes thus carried their burden to demonstrate coverage when they put forward evidence of their losses. And the only way that those losses could not be covered by the broad all-risk coverage provided by the Buchholzes policy is if Crestbrook can prove the cause of loss was excluded. If the panel has any more questions, I'm happy to answer them. Otherwise, I'll save the rest of my arguments for rebuttal.
Yes, you have saved time for rebuttal. Thank you, Mr. Krist.
Good morning, and may it please the court. My name is Brian Gillett on behalf of Crestbrook Insurance Company. In this insurance coverage case, it is undisputed that appellants' losses were caused by mold, and their policy unambiguously excludes losses caused by mold. This court should affirm the district court's grant of summary judgment for several independent reasons that we've set out in our brief.
Mr. Krist says that the mold endorsement should be treated as an exception to an exclusion and not as a coverage provision. Given that choice between one or the other, is he correct or do you disagree?
I would contend that it is irrelevant for the court's analysis whether the mold coverage is treated as an independent coverage or as an exception to it.
I didn't ask you whether it was relevant or irrelevant. It's relevant because I asked the question. So which position do you take? Is it a coverage provision or is it an exception to an exclusion?
It is both, Your Honor. It is both. The court analytically can start by looking for a coverage provision. There's an all-risk coverage provision, but there are also additional property coverages. The mold coverage is number 10 of those additional property coverages. As we've explained in our brief, it is a property coverage. However, there is a mold exclusion, and the mold exclusion specifically identifies one exception, and that one exception is the mold coverage. So the mold coverage is simultaneously a coverage and an exception to an exclusion. And the reason I mentioned earlier why it doesn't really matter for the court's analysis is that under settled Texas law, there is a burden-shifting scheme on who bears the burden of proof in insurance coverage disputes. As an initial matter, the insured bears the burden of proving coverage. If they are able to establish coverage under a coverage provision of the policy, the insurer then bears the burden of proving that an exclusion removes that coverage from coverage.
Give us a hypothetical a fact situation. Obviously, you wouldn't concede it's the facts here. Give us a hypothetical fact situation that would have granted the Buchholzes a benefit from their purchase of the mold endorsement, for which they paid additional premiums.
I don't need to give Your Honor a hypothetical because there are concrete examples within this very case. There were 6 claims that were filed for 5 different water leaks in 5 different rooms in the Buchholz's house, and a 6th claim for freestanding mold that wasn't related to a water leak. In each of the 5 water leaks claims, a water leak caused water damage, and that water leak also caused mold, which then caused mold damage. And in each of those 5 water leaks claims, because there was a covered cause of loss, the water leaks and the water losses, that also resulted in mold, the mold coverage was triggered. There was a covered cause of loss that resulted in mold in each of those 5 claims. And the Buchholzes received full coverage, not only for the water losses that they suffered in those claims, but also for the mold losses that they suffered in those claims. So the court doesn't even need to look for a hypothetical example of where this mold coverage provides value to the Buchholzes, because there are 5 examples of it in the very record of this case.
Why wasn't the 6th?
The 6th,
Why wasn't it covered under the mold provision?
in the 6th claim, there was no separate cause of loss. There was only mold that was found that caused damage.
But was it the same mold that was in the 5 rooms?
It was not, Your Honor. It was not. And that is why the appellants retained M-Law Forensics, Mr. Dean Reed, a professional engineer in the state of Texas, to investigate the cause of the losses in the mold claim and to provide remedial recommendations for how they could prevent that mold from happening again.
Why didn't the mold provision cover that mold,
Because in the mold,
the extra mold provision?
in the 6th claim, there was freestanding mold. And mold is an excluded cause of loss. Their losses in
They
that
bought
section were
extra
caused by mold.
coverage for mold.
Beg your pardon, Your Honor?
They bought extra coverage for mold.
They bought extra coverage for mold in the event that the mold resulted from a covered cause of loss.
But how do you define that under an all-risk policy?
Yeah.
Well, Mr. Krist has suggested that that a covered cause of loss is a cause of loss that's not excluded. Crestbrook doesn't necessarily disagree with that definition. But in this case, There was no other covered cause of loss that resulted in the mold. There was no other covered cause of loss in the freestanding mold claim that resulted in the mold.
But it
there
says
was
all
only,
risk.
Beg your pardon, Your Honor?
It says all risk.
Well, but
Isn't it true that they wouldn't necessarily have to adduce the specific cause of the mold to show a compensable claim under the mold endorsement?
I disagree with that, Your Honor.
Where do you find support for your disagreement in the policy language?
In the policy language, the mold exclusion provides that any losses resulting directly or indirectly from biological deterioration or damage, which includes mold, is excluded.
But the
Except as provided,
mold endorsement says we cover mold from a covered cause of loss.
well, if the court is going to read the mold exclusion as essentially a pass-through and provide that it doesn't actually exclude any mold because there's a mold coverage, then it will have read the mold exclusion out of the policy effectively. And in 1965, in Aetna versus Yates, this court held that that's really improper. That in that case, Judge Friendly, sitting by designation, evaluated a policy provision very similar to this, where the policy excluded causes of loss resulting from mold, from rot, etc. And the plaintiffs experienced rot and mold in their crawl space that was the result of condensation from water. The plaintiffs tried to avoid the effect of that exclusion by arguing that it wasn't really rot, it wasn't really mold that was causing the losses, it was water. There was water condensation. So they experienced a covered water loss.
Your position is effectively set the mold endorsement aside. The Buchholzes have leaks in their house, water damage in their house. But if the mold endorsement is not there as part of the policy, the mold resulting from the water leaks under this all-risk policy would be excluded by the mold exclusion, no coverage at all.
Yes, Your Honor.
So the benefit they get is that, well, 5 of the rooms or 5 of the claims were covered under the mold endorsement as caused by a covered cause, which was the water leaks.
Yes.
I guess what I'm just grappling with, though, is what does covered cause of loss mean in that endorsement? Is it as restrictive as you say it is, and how do we get to there?
Well, there are two ways the court can analyze it. The district court evaluated it by looking at the burden of proof. Texas law assigns the burden of proof to an insured to establish that an exception to an exclusion restores coverage that would otherwise be excluded.
But the district court didn't really go through all of that, did they? The district court just stopped at phase 1, insured, you haven't shown a covered loss.
Well, that's the alternate way of looking at it, Your Honor. The court can look at the mold coverage as a coverage, which is what the district court did, and evaluate whether the insured has established the requirements of that coverage. And it held that they did not. The court could have started with the all-risk provision as a coverage. It is undisputed that the all-risk coverage was triggered. There was accidental direct physical loss in the 6th claim. But then you have to look at the exclusions in the policy, and you reach the mold exclusion, which excludes all of the losses in that 6th claim, except as provided in its one exception. And Texas law places the burden on the insured to establish that an exception restores coverage that would otherwise be excluded. And so in this case, the Buchholzes bore the burden of establishing the requirements of the mold coverage, whether you start with it in the first instance as a coverage, as the district court did, or whether you look at it as an exception to the mold exclusion.
So the district court didn't do all that. I mean, they sort of, like you said, the district court started from reverse, and I say they, it's the magistrate judge and the district court. But should we send this back then? In other words, we vacate and remand so they can go through the calculus provided by Texas law?
No, because any error that the district court would have committed by not looking at this as an exception is harmless, because the same analysis results, whether you start from viewing the mold coverage as a coverage or whether you view it as an exception to an exclusion. Because in both instances, the Buchholzes bore the burden of proving its requirements, and the district court evaluated whether the Buchholzes had met their requirements.
How did they not show a fact issue about covered cause of loss based on the dueling experts?
There were no dueling experts here, Your Honor.
Well, I mean, I'm summarizing what my exchange with counsel opposite, but there are experts that say different things. In other words, the first expert's report was preliminary, according to counsel opposite, and then there were other experts that came in. So tell me about how that doesn't create a fact issue.
So just stepping back, there are not dueling experts. There were two engineers who were retained initially. Dean Reed with MLaw Forensics is a mechanical engineer, he's a forensic engineer, and he was hired to evaluate the cause of the mold. The Buchholzes hired him. I would point the court to page 2319 of the record, which is Mr. Reed's transcript, where he says that Mr. and Mrs. Buchholz were his clients on the project. Their signatures were put there by authority through their business manager. Crestbrook was not his client on this project. Buchholzes hired Mr. Reed. Crestbrook agreed to pay for it because it was part of the investigative costs. That was a concession that the insurance company made to the insureds in this case. Mr. Reed hired a mechanical engineer, Tom Green, who was an authority on HVAC units, to specifically evaluate the HVAC units in that case. Mr. Reed prepared 3 reports. The third was not a preliminary report. It was a final causation report. I've seen the word preliminary mentioned in their briefing. I've seen it in summary judgment briefing. It was not a preliminary report. There is nothing preliminary about it. I encourage the court to read Mr. Reed's causation report. It is only about 10 pages long. It reaches very definite conclusions, and Mr. Reed testified in his deposition that, I'll even point it out, page 2316 of the record. Question, as set out in your report, did you in fact determine what caused the elevated moisture and mold at their house? Answer, I believe we did. Yes. This was not preliminary. They're glomming onto the word preliminary because Tom Green, the HVAC engineer, referred once to his report as preliminary because he anticipated that after he'd evaluated the HVAC units in situ, there would be repairs made to them, and he would perform a second evaluation of those units as repaired. But the Buchholzes elected to simply replace all of their HVAC units and never reach that second stage of the analysis. But that did not prevent Mr. Green and Mr. Reed from reaching conclusions that the HVAC units did in fact contribute to the mold in their house due to their faulty design and the faulty construction within the house.
Is that a different exclusion under the policy?
There is an exclusion under the policy for faults and defects in construction, design, materials, workmanship, and maintenance. Every single one of the causes that Mr. Reed put forward falls within that exclusion. The
District court didn't grapple with that exclusion at all, did it?
The district court didn't need to because turning back to the burden that the Buchholzes faced in putting forward the exception to the exclusion, they had to show the requirements of the exception to the exclusion. And as you mentioned earlier, Your Honor, the exception to the exclusion, the mold coverage, requires that it apply only in the event that the mold result from a covered cause of loss. The only requirement embedded in that is that there be a result from a covered cause of loss. And so if you look at that, there are 2 elements to that. There's a cause of loss, and it has to be covered. And in order for the Buchholzes to bear any burden in this case at all, they at minimum have to show that there was a cause of loss that resulted in the mold. And they didn't do that. And that brings me back to why I was telling Your Honor that there were not dueling experts. There was Mr. Reed and Mr. Green's causation report that the appellants put together and submitted to Crestbrook in an effort to get coverage before litigation. They submitted it to Crestbrook as evidence of what caused the mold at their house, as evidence of a covered cause of loss. And Crestbrook correctly denied their claim because Mr. Reed's conclusions demonstrated that there was not a covered cause of loss, that the mold was the result of construction defects, which are excluded. It was the result of vapor drive, where hot, humid air outside of their house was being driven through the walls and through their attic into the chases, down into the interior walls, where it was not drying out because the house was not correctly constructed. It was a defective construction. The mold grew because of defective construction. And so there was not a covered cause of loss. There was at most an excluded cause of loss under what Mr. Reed said. In litigation, the Buchholzes did not correctly appreciate that they bore the burden of proving coverage or an exception to an exclusion, and that in either event they would have to show a covered cause of loss. So when they retained an expert witness, that expert witness did not determine a cause of loss. He merely limited himself to trying to rebut the opinions that appellant's own engineers had earlier prepared and that they had submitted to Crestbrook as evidence of what caused the losses at their home. Mr. O'Brien explicitly disclaimed that he had any opinion on what caused the Buchholz's losses, on what caused the mold at their house. And so without that, the Buchholzes had no evidence of a cause of loss at all. And so if there's any requirement for the Buchholzes to carry in proving the mold coverage, they would have to show that there was a cause of loss, and they failed to do that. They did not present any summary judgment evidence that could raise a fact question on what caused the losses at their house. And in fact, before the district court on summary judgment, they expressly told the court not to consider the opinions of Reed and Green because they erroneously contended that they were preliminary or they believed that they were not reliable. But without Reed and Green's opinions, there is no evidence of any cause of loss other than mold. And mold is excluded under this policy. In order for the mold to be covered, there has to be a separate and distinct, a discrete cause of loss that causes a loss and also causes mold that causes a loss, as was the case in the water leaks claims. The water leak is a perfect example because water intrusion, a water leak, is a covered cause of loss because it causes losses where the water may hit the wood, it may damage it, the wood needs to be replaced, for example, and the wood may also grow mold. And in that case, the mold is the result of a covered cause of loss. And in the water leaks claims, the Buchholzes correctly carry their burden under Texas law of demonstrating that the mold there resulted from a covered cause of loss, and it was therefore not excluded by the mold coverage. I'd also encourage the court to look at the Aetna versus Yates decision and the Feist decision, which is from the Texas Supreme Court, both of which evaluated similar arguments to what the Buchholzes are making. So recognizing that they do in fact bear the burden of proving that the mold coverage applies because it's an exception to an exclusion or it's a coverage, under either event they bear the burden of proof. They've now contended kind of in a revisionist history that they did put forward evidence of a covered cause of loss. They say that it was the result of an accumulation of water within the walls of their home. Well, we know how that water got there because Mr. Reed determined what caused it. His opinion has not been effectively rebutted. It is the only evidence of causation in this case, other than simply freestanding mold, which by definition is excluded. The policies underlying all risk provisions, which generally, as Mr. Krist said, the idea behind an all risk provision is that when it is difficult to ascertain the cause of a loss, you would presume that there is coverage. Doesn't apply here, because here the default state of the world is that these are mold losses and the policy excludes mold losses. The default state of the world is that there is not coverage. This falls within the third step of the Texas Supreme Court's burden shifting approach, where the default state of the world is that they've shown coverage initially, but then it is undisputed that the mold exclusion removes coverage. And so all we have to do is look at the third step in the process. Have they done what they need to do to restore coverage? And they haven't shown that. They refused to provide evidence of a cause of loss. They've therefore not even reached the step of the analysis where you would have to look and determine whether that cause of loss was covered. But even if the court does, there are 3 other exclusion provisions in this policy that very squarely apply based on undisputed facts. Mr. Reed's causation opinion, which is final, it is not preliminary, and he was their engineer. He offered opinions on what caused the mold in their house, and all of those causes of loss are excluded under the policy. The facts really are not subject to dispute. If the court were to vacate and remand, there would be no fact dispute for the district court to determine, because the only evidence of the cause of loss is what Mr. Reed said, and what Mr. Reed said results in exclusion. I'm happy to answer any further questions that the
All right,
court has.
thank you, Mr. Gillett. Mr. Krist, rebuttal? So Mr. Gillett says that you haven't shown a discrete cause of loss. Would you respond to whether you have, and if so, tell us, even if you're repeating yourself, what specifically we will find in this record as to a discrete cause of loss?
Of course, Your Honor. So we would disagree with Mr. Gillett on that point. In their summary judgment motion, Crestbrook argued that the mold resulted from water and moisture in the walls of the home, which was in turn caused by excluded losses. And the Buchholzes did not dispute that water and moisture in the walls of the home caused the mold. We did dispute that that water and moisture resulted from the excluded causes. And the Buchholzes retained expert Sean O'Brien opined in his declaration, which is at ROA 4154, that the mold resulted because the walls and ceilings of the home were exposed to significant water intrusion. At summary judgment, Crestbrook also argued at ROA 1807 that the record conclusively establishes that the mold developed because the water accumulated in the walls of the home. So there really was no dispute there. Setting aside that issue, it's the Buchholzes' position here that...
So the discrete cause of loss, again, you're probably repeating yourself, but tell us in a sentence, the discrete cause of loss was what?
Water and moisture in the walls of the home, Your Honor. And there is a dispute between the parties as to how that water and moisture got there. But the reason all risk policies exist is to provide coverage in situations like this where it's difficult, if not impossible, to determine with real certainty exactly how a loss occurred. That's why Texas law puts the burden on Crestbrook to prove whether an exclusion applies.
So if it was, as Mr. Gillett says, caused by construction defects, you say that it would still be covered?
If Mr. Gillett was correct that it was caused by construction defects, we would argue first that there's a fact issue as to whether that's true based on the conflicting expert testimony, but second, that the mold is a resulting loss that is a distinct peril, different in kind from the construction defect, and it would fall within the scope of the resulting loss exception to that defect's exclusion.
So your position is very close to almost strict liability. If there's mold, there's coverage, at least in terms of the plaintiff's initial burden.
I would agree with that, Your Honor, and I'd like to point out something that Mr.
Well, I don't know that I agree with it, but I'm saying that's your position. Effectively, I mean, I guess to put it in the counsel opposite's vernacular, the Buchholzes really didn't have to show anything other than here's mold. Again.
Excuse me, Your Honor. I would agree that the Buchholzes only had to put forward evidence of accidental direct physical loss, and the burden to identify an excluded cause of loss or an exclusion that applies falls on Crestbrook. Mr. Gillett argued when he was up here that the analysis would be the same under the initial coverage of the policy and under the exception, and I agree with that. Under the initial coverage of the policy, the Buchholzes just had to show evidence that they incurred losses, and it's Crestbrook's burden to show whether an excluded cause resulted.
Well, they've got to show they've had covered losses. I mean, that's what the language says, covered cause of loss. So they do have some burden to show that, right?
The Buchholzes do have a burden to put forward evidence of a covered cause of loss, but by putting forward evidence of accidental direct physical loss, that is evidence of a covered cause of loss because all
That's
causes...
evidence of a loss, but is it evidence, is that equivalent to evidence of a covered cause of loss?
I believe it is, Your Honor, because all causes are covered by this policy unless excluded.
But there are exclusions. Construction, design, the mold exclusion itself.
That's correct, Your Honor, and Crestbrook bears the burden on those exclusions. If the Buchholzes were required to identify a particular cause of loss that doesn't fall within the scope of an exclusion, then that would be effectively inverting the parties' burdens here, and it really wouldn't matter what cause of loss the Buchholzes identified because their coverage does not hinge on that cause. If they said that the mold in their house resulted from really, you name it, they would still be entitled to coverage because that mold is accidental direct physical loss covered by the policy unless an exclusion applies. I would like to briefly address the expert testimony point that Mr. Gillett raised. He is I think, suggested that the Buchholzes are bound by the MLaw report and the initial report issued by Dean Reed. I don't believe that's the case. The Buchholzes went out and hired an additional expert in order to opine on that, and they found a fact issue existed as to what caused the mold.
Thank you, Mr. Krist. Your case is under submission.